Hello and welcome to An Academy. Indian polity is one of the most important subjects for the civil services examination. Each year, on an average, 15 to 17 questions are asked from Indian polity in the prelims examination. If you notice the PYQs, a large number of such questions from Indian polity are asked in such a manner as if the statements are directly lifted from this book, the bare act, the Constitution of India. It is my endeavor that in 2 sessions, we will comprehensively cover this bare act, the Constitution of India, all the important articles of the Constitution. Today is session number 1, tomorrow at the same time, session number 2. So if you're preparing for the civil services examination, or for that matter, any exam in which Indian polity or the Constitution of India is one of these subjects, these 2 sessions are extremely important. Now listen to me carefully. In the prelims examination, the questions from Indian polity can be asked either from the static portion of your syllabus or the dynamic portion, which is the current affairs. If the question paper is dominated by the static portion of your syllabus, then you can answer all these questions by attending these 2 sessions, guaranteed. So if I have given you that assurance, I need an assurance from you as well, that you will like this video and subscribe to our channel if you haven't yet. Let's get started and let's look at this beautiful discussion on the Constitution of India. But first up, a brief overview. Indian Constitution, considered to be one of the lengthiest constitutions in the entire world. It's spread across 395 articles, although the number of articles are more than 450. But if you look at the numbering, the articles are numbered till 395. For example, we have Article 21 and we have 21 capital A, although 2 different articles, but the numbering is 21. Similarly, Article 51 and 51 capital A, although 2 different articles, but the numbering is 51, which means although the number of articles are more, but these are numbered till 395. Number 1. Number 2, although in the original constitution, when it was enacted in 1950, the number of schedules were 8. Over a period of time, 4 more schedules have got added to the constitution. So today we have 12 schedules of the constitution. Third, our constitution is spread across 22 parts. Now listen to me carefully. Although the number of parts are 25, but the parts are numbered till 22. What does that mean? Part 9 of the Constitution deals with panchayats. Part 9 capital A deals with municipalities. Part 9 capital B deals with cooperative societies, which means although the part is 9, but it is numbered part 9A, 9B and 9, which means although the number of parts are 25, but they are numbered till 22. And since the enactment of the Constitution, our Constitution has been amended 106 times. The last amendment was in the last year in 2024 when Women's Reservation Act was passed, when the Constitution provided for reservation for women in Lok Sabha and the state legislative assemblies. Although this Constitutional Amendment Act is not in force, because for that, we first need to carry out the delimitation exercise. And for that, we first need to carry out the census. So if at all, this Constitutional Amendment Act has to enter into force, we may have to wait beyond 2029. Our Constitution begins with the preamble. Just like the American Constitution begins with the preamble. We the people of India, which the Supreme Court has said in the Keshavananda Bharati versus State of Kerala 1973 that preamble is part of the Constitution. Our Constitution begins with we the people of India, and this is where we say the Constitution has created a legal fiction. What is that legal fiction? Although the Constitution was drafted by the Constituent Assembly, adopted by the Constituent Assembly, not directly by the people, but a legal fiction has been created as if this Constitution has been adopted by the people of this country. So what is the source of authority of this constitution? From where does this constitution derive its authority from? That is, we the people of India. Second, this preamble tells us what is the nature of Indian state. And what is that nature? Our state is sovereign, socialist, secular, democratic republic. And if you notice this carefully, all these things are mentioned in the capital letters and there is no comma separating one from the other. There is no comma separating sovereign from socialist, socialist with secular, so on and so forth. Which means constitution envisages that this entire thing should be treated as if it is a composite whole. It's an integrated term, integrated phrase. That means we cannot be sovereign without being secular, socialist, democratic and republic. This has to be treated as an integral whole. And then the preamble also tells us what are the objectives that we want to achieve through this constitution. Liberty, equality, fraternity, dignity of an individual. Which means although preamble is not enforceable in a court of law, but then what is the significance of this preamble? We say this preamble can be used to interpret the provisions of the constitution if these provisions are found to be ambiguous. For example, in 2017, a 9-judge bench of the Supreme Court had to decide whether right to privacy exists under the constitution as a fundamental right. And all these 9 judges, through a unanimous verdict, said that right to privacy is a fundamental right guaranteed under Article 21 of the Constitution. And Supreme Court came to this conclusion by looking at the preamble of the Constitution, which talks about dignity of an individual. The Supreme Court said that dignity of an individual is not possible unless and until you have privacy. So right to privacy is a fundamental right under right to life. And the last thing that this preamble tells us is the date on which the Constitution was adopted. And it was adopted on 26 November 1949, although it came into force on the 26th of January 1950. And for that, you have to understand the history behind 26th January. And for that, you have to revise your modern history. And you have to look at the Purna Swaraj, the resolution which was passed by the Congress in 1929 at the Lahore session of the Indian National Congress. But be that as it may, this preamble was also amended. Although you would know that 2 terms got added to the preamble. One was socialist, the other was secular, and this was done through 42nd Constitutional Amendment Act 1976. But there was another term which was added through the same Constitutional Amendment Act, and that is something that you have to keep in mind. And that term is the integrity of the nation. So originally the Constitution said unity of the nation, and then another term was added, integrity. So in 1976, 42nd Constitutional Amendment Act, socialist, secular and integrity of, these were the terms which got added to the preamble in 1976. This is about the preamble of the Indian Constitution. Now let's look at part 1 of the Constitution, which talks about union and its territory. Article 1 says, India, that is Bharat, shall be a union of states. Which means you need to understand that we have dual name for this country, India as well as Bharat. And despite the fact that we are a federal polity, we have a federal setup, Dr. Ambedkar said, I have used the term Union of States under Article 1, Clause 1, primarily because no state has the right to secede from the Union of India. Because if it is a federation, federation is constructed through a treaty, through an agreement. When different units, they come together through a treaty, through an agreement to create a federation. Dr. Ambedkar said that is not how India was created. India was not created through an agreement or a treaty. And no state has the right to secede from the Union of India. That is why Dr. Ambedkar said, despite the fact that ours is a federal polity, but I've used the phrase Union of States instead of Federation of States. And Article 1 further said that all the names of the states and union territories, they shall be specified where? in the first schedule of the Constitution? So first schedule of the Constitution talks about the names and territories of 28 states and 8 union territories that we have. Further, Article 1 says that the territory of India shall consist of either we can have states, or we can have union territories, or we can have acquired territories. One more important thing. When Article 1 Clause 1 says India, that is Bharat, shall be a union of states, does this term state include union territories? No, because union territories are directly controlled by the center. Union territories do not share federal relationship with the center. It's only the states which share federal relationship with the center. So this phrase, India, that is Bharat, shall be a union of states. This phrase, union of states, includes only the 28 states and not the 8 union territories that we have. Article 2 talks about admission or establishment of new states. What Parliament can do, Parliament can enact a law, and through this law, Parliament can admit into union or establish new states on such terms and conditions as it thinks fit. To understand this, let's also look at Article 3, and then I will tell you the difference between Article 2 and Article 3. Article 3 talks about existing states, that these existing states can be bifurcated, can be trifurcated, can be merged with other states. The area can be increased, the area can be decreased, the boundaries can be altered, the name can be changed. So Article 3 talks about existing states. Article 2 talks about admission of states into Union of India. That means those states which were not in existence. For example, there have been large number of territories which have been acquired by the government of India. For example, few Portuguese colonies. For example, Sikkim was acquired by India. Although, listen to me carefully, Article 2 was not used in those cases. It was Article 368 which was used. So Article 368 was used to admit Sikkim first as an associate state and then as a full-fledged state. Similarly, Daman and Diu, Dadra and Nagar Haveli, Puducherry, Goa, these were acquired using Article 368. Perhaps the only entity which was added to the Union of India using Article 2, that was Chandranagar. For all other states, all other territories which were acquired, we used Article 368. But Article 2 gives the power to the Parliament that you can enact a law, and through this law you can admit into union or you can establish new states on such terms and conditions as it thinks fit. What does that mean? What does this phrase mean, as it thinks fit? Listen to me carefully. We have existing states, 28 states. And for them, we have under Schedule 7 of the Constitution, state list. That means on all these items mentioned in the state list, who has the power to make laws? State legislature. Now, if a new state has been admitted into Union of India using Article 2, this new state cannot claim parity with the existing states. Which means for this new state, maybe some items may not be provided, which are provided under Schedule 7 of the Constitution for other states. That's Article 2 of the Constitution. And Article 3 talks about formation of new states, altering the boundaries of the states, changing the name of the state. And this is considered to be one of the centralizing features of Indian federalism. Centralizing features in the sense that this power is available to the Parliament, to the central legislature, not to the states. So Parliament, the central legislature, can change the area of a state, increase the area, decrease the area, alter the boundaries, change the name of the state, merge two or more states, bifurcate states. But for that, Article 3 also talks about a consultative process. Which means if you want to reorganize a state, this bill, which can be introduced in the Parliament to reorganize that state, it cannot be introduced in the Parliament without the prior approval of the President. So a bill under Article 3 requires prior approval of the President of India. But before President can give his approval to this bill, the President will have to refer this bill to the legislature of that state which is going to be affected by this bill. Which means when Andhra Pradesh was reorganized in 2014, Andhra Pradesh Reorganization Bill was introduced in the Parliament under Article 3. Such a bill required prior approval of the President. But before President gave his approval, President referred this bill to the Andhra Pradesh Legislative Assembly which was going to be affected by this bill, asking the views of Andhra Pradesh Legislative Assembly. But these views are not binding on the President. Which means if the President is given a view by the legislature that we don't want reorganization, we don't want bifurcation, that doesn't mean the President is bound by that view. President can still go ahead, give his approval to the government, introduce a bill under Article 3 in the Parliament and reorganize that state. Now listen to me carefully. This topic is important because of, some would say, a controversial interview given by former Chief Justice of India, Justice Chandrachud, first to the BBC and then to Barkha Dutt, wherein he said that Article 3 is ambiguous. Ambiguous in the sense, listen to me carefully. Explanation number 1. In this article, from clauses A to E, state includes union territory, but in the proviso, state does not include a union territory. What is the proviso? Provided that if you want to reorganize a state, you have to get the prior approval of the President. And President will have to send this bill to a state which is going to be affected by that bill. This does not apply if you want to reorganize a union territory. Which means if Delhi or Puducherry or Jammu and Kashmir is to be further reorganized, for that the President need not send this bill to the legislature of these union territories because they will be affected by this bill. No. This consultation process is only for states, not for union territories. But from A to E, it includes union territories, which means, can Parliament create a union territory using Article 3? Yes. That is why in Jammu and Kashmir reorganization case, the Supreme Court upheld the creation or the carving out of Ladakh as a union territory. Supreme Court said, yes, this is fine because that's the power available to Parliament under Article 3, which means you can convert a part of that state and make that part a union territory. That's the power under Article 3. But does that power include converting an entire state into a union territory? This matter was left undecided by the Supreme Court. Which means what? Jammu and Kashmir was reorganized and bifurcated into union territories. Jammu and Kashmir, one UT, Ladakh, another UT. Supreme Court upheld that yes, Ladakh can be carved out as a union territory. Why? Because that's the power available with the Parliament under Article 3. Because Article 3 gives you the power that you can form new states, which include forming a new union territory from the existing state. But what will happen to the residue, the remaining state, Jammu and Kashmir? Is it constitutional on part of the Parliament to convert that residue into a union territory as well? The Supreme Court did not answer this question. Why? Because Supreme Court said we will go by the assurance given by the Solicitor General. And the assurance was that the UT status for Jammu and Kashmir is temporary. We will restore statehood to Jammu and Kashmir. And the Supreme Court said if such an issue comes before us again, then we will decide whether entire state can be converted into union territories. Because if that is the power given to the Parliament, then Article 1, Clause 1 would become India, that is Bharat, shall be a union of union territories. Which means then federal principle would be violated. And federalism is considered to be part of the basic structure of the Constitution. Further, Article 4 of the Constitution says, when you pass a law under Article 2 and 3, there you have to make changes to Schedule 1 of the Constitution. Because Schedule 1 talks about the name and territory of states and union territories. Schedule 4 talks about the representation of states in Rajya Sabha? Sir, what are you trying to say? Prior to 2014, Schedule 1 would say Andhra Pradesh. Schedule 4 would say that from Andhra Pradesh, 18 MPs would be elected to the Rajya Sabha. Now you have reorganized Andhra Pradesh into Andhra Pradesh and Telangana. That means in Schedule 1, you have to now mention Telangana. That means you have to amend Schedule 1. And in Schedule 4, you have to reduce number of MPs from Andhra Pradesh from 18 to 11. And from Telangana, you have to provide 7 MPs to Rajya Sabha. That means 18 has to be split, 11 for Andhra, 7 for Telangana. That means you have to change Schedule 1, Schedule 4. But Article 4 says these are incidental matters, consequential matters. And that is why they shall not be deemed as amendment to the Constitution. Which means if you want to amend Schedule 1 and Schedule 4 of the Constitution, for that you don't need to use Article 368. For that you don't need a special majority. You can pass a law by simple majority. It should be an ordinary law to change Schedule 1 and Schedule 4. That's Article 4 of the Constitution. Which means, long story short, if the Parliament is using its power under Article 2 and 3, because you are using the power under Article 2 and 3, because you are admitting a new state into the Union of India, or because you are reorganizing an existing state under Article 3, there will be changes to Schedule 1 and Schedule 4. Schedule 1 talks about name and territory. Schedule 4 talks about representation of states in the Rajya Sabha. These changes are supplemental, incidental, consequential matters, and these changes shall not be deemed as an amendment to the Constitution, which means you don't need to use Article 368. Then we come across Part 2 of the Constitution, which deals with citizenship. And listen to me carefully. Part 2 of the Constitution, which deals with citizenship, from Articles 5 to 11, the real power is with the Parliament. That Parliament, you can enact a law, and through this law, you can regulate all matters related to citizenship. And this power is given to the Parliament under Article 11 of the Constitution. So what does Part 2 deal with? Part 2 deals with citizenship at the time of the commencement of the Constitution. At the time of the commencement of the Constitution, who is a citizen of India? Who cannot be the citizen of India? That's mentioned under Part 2 of the Constitution. What about after the commencement of the Constitution? For that, Parliament will have to enact a law using Article 11. And Parliament has done that by passing a law called the Citizenship Act of 1955. And it is this law which has been amended multiple times, and the last amendment was in 2019, which is what we call the Citizenship Amendment Act of 2019, under which the Parliament said, if you are from Pakistan, Afghanistan, Bangladesh, and if you have entered India on or before December 31, 2014, and if you belong to the 6 religious minorities of these 3 countries, Hindus, Christians, Buddhists, Jains, Sikhs, Parsis, then you shall not be deemed as a legal migrant. When you are not deemed as a legal migrant, that means you are eligible for citizenship. Through which route are you eligible for citizenship? Naturalization. So Article 11 gives power to the Parliament that you can enact a law, and through that law you can regulate all matters related to citizenship. And the remaining articles talk about citizenship at the time of the commencement of the Constitution. Now listen to me carefully. Constitution entered into force on 26 January 1950. Yes or no? Yes. But the provisions related to citizenship came into force on the 26th November 1949 itself. That means it's not that the entire Constitution came into force on 26 January 1950. There were some provisions, for example, citizenship provisions, which came into force on 26 November 1949 itself. What does Article 5 talk about? Citizenship at the time of the commencement of the Constitution. Which means at the time of the commencement of the Constitution, who is the citizen? And Constitution says, if you were born in the territory of India, or if you were born to parents who were born in the territory of India, and you have been residing in the territory of India for 5 years, you are a citizen of India. So if you were born on the soil of India, you are the citizen of India, which means we were following the concept of Yasoli, law of the soil. Whoever is born within the territory of India and has been staying in India for 5 years, you are the citizen of India, regardless of the nationality of your parents. But Article 6 talks about rights of citizenship of those persons who migrated to India from Pakistan. So if the country was partitioned into India and Pakistan, now what about those who are residents of Pakistan, who are born in this area called Pakistan? If you want, you can migrate to India and we will give you citizenship. But for that, you have to migrate before 19th of July, 1948. This is the cutoff date for citizenship. That means if you were born in what is now called Pakistan, and if you want to migrate to India, then you should migrate to India before 19th July 1948. If you migrate before that, we will grant you citizenship. Article 7 talks about what about the citizenship rights of those who migrate to Pakistan. Constitution says, if you have migrated from India to Pakistan after 1st March 1947, you are not the citizens of India. Which means if you have migrated from India to what became Pakistan after 1st March 1947, you are not the citizens. But then if you want to come back, if such people who migrated from India to Pakistan, if they want to come back, they have to come back before 19 July 1948, and that too with the permission under the permit system of the central government. And you have to return to India, and that is what we call permanent return. You have to return to stay in India permanently. Which means Article 5 talks about citizenship at the time of the commencement of the Constitution. But now there are two waves of migration which took place. After 1st March, when people from India migrated to Pakistan. And then after 19th July 1948, when people from Pakistan migrated to India. Constitution says, what about those who migrate from Pakistan to India before 19 July 1948? We will give them citizenship. But what about those who migrated from India to Pakistan after 1st of March 1947? You are not the citizens. But if you want to then return, you have to return only if we give you the permit. Only with our permission, you can return back to India. And for that, you have to return to India before 19 July 1948. Article 8 talks about what if you are eligible to become the citizen of India, but you are not in India, you are residing outside the territory of India. Then you can register as the citizen of India in an Indian embassy or an Indian consulate. So what about the citizenship rights of those who are of Indian origin but residing outside of the India, outside the territory of India? There you have to register as the citizens. And Article 9 talks about single citizenship, which means if you renounce Indian citizenship, if you acquire the citizenship of a foreign country, then you are no longer the citizens of India, which means we do not recognize dual citizenship. Which means if the question is asked in the examination, dual citizenship is something which is not acceptable to India. Is it because of the Citizenship Act only? No, it is also because of the Constitution. Because Article 9 says those who voluntarily acquire the citizenship of a foreign country, they will not remain the citizens of India. But citizenship at the time of the commencement of the Constitution is provided by a Part 2 of the Constitution. Article 10 says if you were given citizenship under this part, you will continue to remain the citizens after the commencement of the constitution as well. That means continuance of the rights of citizenship. If you were granted citizenship by part 2 of the constitution, even after the commencement of the constitution, such people will continue to remain the citizens of India, subject to the law passed by the Parliament under Article 11. That means the Parliament of India has the real power to regulate all matters related to citizenship. And the matters related to citizenship shall be governed by this law called the Citizenship Act of 1955. This is part 2 of the Constitution. Let's come to part 3 of the Constitution, fundamental rights. And this is where we will have to focus on Articles 12 to 35. What does Article 12 talk about? Throughout this discussion on fundamental rights, we will come across a term called state. The state shall not deprive an individual of his right to life or personal liberty. The state shall not discriminate. The state shall not deny equality. The state shall not do this. The state shall not do that. Which means fundamental rights are basically limitations on the powers of the state. You can claim fundamental rights from the state, but who is this state from whom you can claim your fundamental rights? The definition of that state is provided under Article 12 of the Constitution. And Constitution says under Article 12, state means the government of India, the Parliament of India, the government of a state, the legislature of a state, the local authorities, as well as other authorities. But one important thing, what is this other authority? That is not defined in the Constitution. For that, there is a Supreme Court's interpretation, but we don't have to get into that because right now in these lectures, we are focusing on the bare act. What is mentioned in the Constitution, that's it. Nothing more, nothing less. So Article 12 talks about the definition of the state, and Article 13 talks about those laws which are inconsistent with fundamental rights. Listen to me carefully. Article 13, Clause 1. What does it say? If there is a law which has come into operation, which was in force prior to the commencement of the Constitution, can this law which was in force prior to the commencement of the Constitution continue even after the commencement of the Constitution? Yes, if this law is in agreement with fundamental rights. If this law is inconsistent with fundamental rights, then this law will not continue after the commencement of the Constitution. Further, Article 13, Clause 2 states that state cannot pass any law to delete or modify or abridge fundamental rights. That's not the power available with the state. And what is this law? The law can be rule, regulation, bylaw, custom, usage, ordinance. Through this law, you cannot delete, modify, abridge fundamental right. But can you delete a fundamental right? Can you modify a fundamental right? Can you abridge a fundamental right? Can Parliament do that? Yes, but only under Article 368 of the Constitution, which means not through the ordinary law, but only through a Constitutional Amendment Act. But now listen to me carefully. This is where we will slightly link it with current affairs. What is that link? This is an ordinary law. On what grounds can an ordinary law be challenged before the court? On what grounds? Only two grounds. One, if this law violates fundamental rights. Second, legislative competence. Sir, what are you saying? I am saying Article 3 talks about that all laws which were in force prior to the commencement of the Constitution, can these laws continue even after the commencement of the Constitution? Yes, if these laws are consistent with fundamental rights, in agreement with fundamental rights. What if these laws are inconsistent or violate fundamental rights? Then these laws will not continue further, because fundamental rights are sacred. And can the state pass any law to delete, modify, abridge fundamental right? No. Through an ordinary law, you cannot. Through regulation, you can't. Through ordinances, you can't. If at all, you have to violate, delete, modify, abridge fundamental right. For that, you have to pass a Constitutional Amendment Act under Article 368 of the Constitution. But this Constitutional Amendment Act shall not violate basic structure. Because Supreme Court in Keshavananda Bharati case in 1973 said there is something called basic structure which no Constitutional Amendment Act can violate. But what about an ordinary law? Can an ordinary law be challenged in the court of law because it violates basic structure? The answer is no. Really, sir? Yes. Ordinary laws can be challenged before the court only on two grounds. Not on the grounds that they violate basic structure. Only on two grounds. What are these grounds? Number one, if they violate fundamental rights. Because that is the explicit wording of Article 13. And second, legislative competence. Competence in the sense, if this law was passed by the state legislative assembly, but state legislative assembly does not have the competence to pass this law, in a sense, what if the state legislature passes a law on currency, on insurance, on banking, on citizenship, on extradition? You can't do that. Why? Because that is beyond your legislative competence. Because on all these matters, only Parliament has the power to make law. Similarly, can Parliament enact a law on police, on law and order, on gambling? No, because that is beyond its legislative competence. That is within the competence of the state legislature. So, ordinary laws can be challenged on the grounds of violation of the fundamental rights and testing whether that legislature had the competence in enacting that law. An ordinary law cannot be challenged on the grounds that it violates basic structure. Constitutional Amendment Act can be challenged before the court of law on the grounds that this Constitutional Amendment Act violates basic structure, but not an ordinary law. For that, maybe we will have an elaborate discussion sometimes, maybe during in the run-up to the mains examination, because this is an important matter. But for the prelims, just understand this thing. Then right to equality, covered under Articles 14 to 18. Article 14 talks about equality before law. Constitution says the state shall not deny to any person, which means this fundamental right is available to aliens as well as the citizens. Both. The state shall not deny to any person what? Equality before law or equal protection of the laws, that too within the territory of India. And within Article 14, we say there is another right called right against arbitrariness. That means the legislature cannot pass a law which is arbitrary. Right against arbitrariness is a fundamental right under Article 14 of the Constitution. Full stop. Article 15 talks about prohibition of discrimination on the grounds of religion, race, caste, sex, place of birth. Please remember and memorize these 5 things. Because this Article 15 is available only to the citizens. This Article 15 is not available to aliens, only to the citizens. And Constitution imposes a limitation on the state that you cannot discriminate against the citizens only on these grounds. Which are these grounds? Religion, race, caste, sex, place of birth. Which means, can the state discriminate? Yes. But for that, there must exist another ground. Another ground can be, maybe on the grounds of age, there can be discrimination. Maybe on the grounds of educational qualification, there can be discrimination. Maybe on medical grounds, there can be discrimination. But only on the grounds of religion, race, caste, sex, place of birth? No. And Article 15 further helps us in our fight against untouchability. More specifically, Article 15, Clause 2, which says no citizen shall be discriminated only on the grounds of religion, race, caste, sex, place of birth when this citizen wants to access public ghats, burial grounds, cremation ghats, public property, for example. Which means this Article 15 helps us in our fight against untouchability as well. But this Article 15 is not absolute because there are exceptions. Exceptions in the sense that the state is empowered to make special provision. Special provision for whom? Women and children. The state is empowered to make special provision for whom? Those who are socially and educationally backward. The state is empowered to make a special provision for whom? Those who are from economically weaker sections of the society. And that is how this Article 15 has been used to provide reservation of seats in educational institutions. For example, for SCs and STs, because these SCs and STs are considered to be socially and educationally backward. Then reservation of seats for OBCs, because they were considered socially and educationally backward. Then in 2019, because of the 103rd Constitutional Amendment Act, another reservation was provided to economically weaker sections of the society. Which means Article 15 talks about non-discrimination against the citizens by the state only on the grounds of religion, race, caste, sex, place of birth. But there are exceptions. The state is empowered to make special provisions for women and children, for socially and educationally backward, for economically weaker sections of the society. And in fact, the most important clause under Article 15 is Article 15, Clause 4, which was added by the first Constitutional Amendment Act. The year was 1951. Further, Article 16 talks about equality of opportunity in the matters of public employment. And just like Article 15, this Article 16 also is exclusively available to the citizens. It's not available to aliens, which means the state is prohibited from discriminating against its citizens only on the grounds. Now, these grounds you will have to remember. In Article 15, it was religion, race, caste, sex, place of birth. In Article 16, it's again religion, race, caste, sex, place of birth, but residence as well, descent as well. That means there are 7 grounds on which the state is prohibited from making discrimination. Which means if the state wants to discriminate, there must exist an 8th ground, nth ground, on which valid discrimination can be made. For example, discrimination can be on the grounds of age. Discrimination can be on the grounds of educational qualification. Discrimination can be on medical grounds, but not only on the grounds of religion, race, caste, sex, place of birth, residence, and descent. Now listen to me carefully. I will take you back to the discussion on citizenship. Constitution talks about single citizenship, and Constitution talks about single domicile as well. Although what is this domicile? It is not defined in the constitution. But what is this domicile? Residence plus the intention to reside permanently for an indefinite period. That's domicile. And the Supreme Court has said there is single citizenship in India, there is single domicile as well, which means you are domiciled within the territory of India. And in fact, this was one question asked in your prelims examination as well previously. There is single citizenship and there is single domicile. The court has said, yes, on the grounds of domicile, there can be reservation in educational institutions. And it is only for that purpose we use domicile. Otherwise, there is single citizenship, there is single domicile. Similarly, Article 16 also provides for exceptions. What are exceptions? Exception, for example, 16 clause 3. What is that exception? If the Constitution says that on the grounds of residence there can be no discrimination, that's a very important point, listen to me carefully. If the Constitution says there can be no discrimination in the matters of public employment only on the grounds of residence, 16 clause 3 empowers Parliament. That what Parliament you can do? Parliament can prescribe residence as a qualification for certain jobs, but only at the state level, not at the union level. Which means although there can be no discrimination only on the grounds of residence, but exception is Parliament has been empowered by the Constitution that through law you can prescribe residence as a qualification for certain jobs. For that you need to understand Article 371 capital J, where Parliament has prescribed reservation on the grounds of residence, that if you are a resident of these 6 backward districts of Hyderabad Karnataka region, which is now known as the Kalyan Karnataka, Raichur, Bidar, Gulbarga, Bellary. If you are from these 6 backward districts of Hyderabad Karnataka region, you will have reservation in state level jobs. But this residence as a qualification can be prescribed not by the state legislature, but by the Parliament. And that too for state level jobs, not for the union level posts. And it is this Article 16 which also provides for reservation in jobs for socially and educationally backward classes of citizens. Initially for SCs and STs, then for OBCs, and then the Constitution was amended again to provide for reservation of seats in public employment for economically weaker sections of the society. One important thing which can be relevant for your prelims exam: can on the grounds of religion state discriminate? No. But what if the state has to appoint somebody to a Waqf board which deals with the Muslims, or to a Gurdwara Prabandhak committee which deals with the Sikhs, or to a, let's say, Tirumala Tirupati Devasthanam which deals with the Hindus? You can provide that to these entities you should be the follower of that religion, or you should prescribe to that religion. Which means religion can become a qualification if you are appointed to these religious institutions, and that is not violation of Article 16. Now Article 17 talks about abolition of untouchability. But if you notice this clearly, untouchability is mentioned in quotes. And this term untouchability is not defined in the Constitution. Which means we are not referring to the literal meaning of this term untouchability. Which means if you are suffering from COVID-19 affected by COVID-19 and you are quarantined in your home and you are not allowed to move out, you cannot claim that untouchability is being practiced, because that's not the untouchability that Constitution refers to. We are referring to the historic practice of untouchability, which was practiced after the later Vedic period. Untouchability on the grounds of caste. That untouchability, Constitution says, has been abolished, and its practice in any form has been forbidden. But the enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. Which means, although Article 17 talks about abolition of untouchability and its practice is forbidden in any form, but you have to enforce this Article 17. It cannot automatically enter into force. You have to enforce it. How? By passing a law. And for that we have the Atrocities Act, famously called Atrocities Act, although it is SC/ST Prevention from Atrocities Act of 1989, which has been also amended multiple times, under which the presumption of guilt is there. Presumption of guilt in the sense, if you are accused under the Atrocities Act, the courts will assume that you have practiced untouchability. The courts will assume that you are guilty. The burden of proof is on the accused. You have to convince the court that you are innocent, not the prosecution. But Article 17 says untouchability is abolished and its practice in any form is forbidden. But what is this untouchability is not defined, which means it is in courts, which means we are not talking about the literal meaning of this term untouchability. We are referring to the historic practice of untouchability. And Article 18 talks about abolition of titles. Titles which used to be given during the British rule. Sir, Rai Bahadur. Such titles are abolished. That means no title can be awarded, conferred by the state, except if these are military or academic distinctions. For example, the court in Balaji Raghavan versus Union of India in 1996 upheld the Padma Awards, the Padma Vibhushan, Padma Bhushan, Padma Shri, as well as the Bharat Ratna, saying these are not titles within the meaning of Article 18. Which means even if we want to abolish titles, but that does not mean merit should not be recognized. These awards, Padma Awards, Bharat Ratna, is conferred on meritorious people, recognizing merit. These are not titles and cannot be used as titles. But no title except military or academic distinction can be conferred by the state. And in fact, no citizen can accept a title from a foreign country. For that, there is one example that I often cite in my classes. For example, Sunil Gavaskar. He became the first test cricketer to score 10,000 test runs. And he was all set to be knighted by the Queen of England. He would have been called Sir Sunil Gavaskar. The title of Sir could have been conferred on him, just like Sir Donald Bradman, Sir Richard Hadley, Sir Ian Botham, Sir Salman Rushdie. But then somebody told him that you can't accept this title because no citizen can accept the title from a foreign country, from a foreign state. But if he would have asked me, I would have told him, go ahead and accept this title. Why? Nothing will happen to you. Go and accept. Why? Because this Article 18, if somebody accepts a title, what is the punishment for that individual? For that you have to provide a law. That law has not been provided at all. That law has not been enacted at all. So somebody violating Article 18, it is not enforced. But be that as it may, that's a separate matter altogether. Article 18 talks about abolition of titles. No title except a military or academic distinction shall be conferred by the state. Let's look at a previous year question. Prelims 2020. Which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? Let me know in the comment section what is the right answer. Some of you would have said right against exploitation because untouchability looks like you are being exploited. But untouchability comes under Article 17. And we discussed that right to equality comes under Article 14 to 18. That means which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? The answer is D, right to equality. This is how questions are asked in your prelims examination from the Bare Act. Let's look at another category of fundamental rights, right to freedom, from Articles 19 to 22. Article 19 is available only to the citizens. That means now, apart from Article 15 and Article 16, which are exclusively available to citizens, we have another fundamental right which is exclusively available to citizens, which is Article 19. And Article 19, Clause 1 talks about various natural rights, as we call them. 19.1a, freedom of speech and expression. 19.1b, right to assemble peacefully without arms. Right to form unions, associations, and cooperative societies. And in fact, this cooperative society originally was not part of the Constitution. It was added through the 97th Constitutional Amendment Act 2011. Then we have right to move freely throughout the territory of India. Right to reside and settle in any part within the territory of India. And both these articles are meant to uphold one objective mentioned in the preamble of the Constitution, which is fraternity. Because when you are moving freely throughout the territory of India, which means no restriction whatsoever, when you are residing and settling in any part within the territory of India, which means people from north can move to south, from south to east, east to west, that's how we can build fraternity, a sense of common brotherhood. And Article 19.1f was deleted, was omitted by the 44th Constitutional Amendment Act 1978. This was the right of every citizen to acquire and dispose of property. And Article 19, Clause 1, Clause G, it talks about the fundamental right of every citizen to carry out any profession, any occupation, any trade, any business. But sir, from these topics, what sort of question can be asked? These rights under Article 19 are not absolute. Which means either on Article 19 we have reasonable restrictions or we have exceptions. First, what are the reasonable restrictions on Article 19.1a? Please remember these 8 reasonable restrictions, which means your freedom of speech and expression can be restricted under Article 19, Clause 2. And there are 8 reasonable restrictions: sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, defamation, incitement to an offense, morality or decency, and contempt of court. These are the 8 reasonable restrictions. For example, if you know the Ranveer Allahabadiya Samay Raina controversy on the grounds of decency or morality, although no matter how horrible that statement was, but it does not fall under the category of obscenity. Sir, what do you mean by that? Then what will fall under this category obscenity? For example, tell me how many amongst you are aware of what Mr. Allahabadiya spoke in that program? You're aware or you're not aware? Yes. By reading that statement or by listening to that statement, what is the feeling that you get? Is it the feeling of disgust or is it the feeling of lust? If that statement generates the feeling of lust, that is covered under obscenity and immorality. That is a reasonable restriction. But if it incites the feeling of disgust. That means, although it's a horrible comment, but does not invoke or attract criminal sanction. But be that as it may, one more type of question can be asked from this. Originally, there were 4 reasonable restrictions. Later on, 4 more reasonable restrictions got added. You may be asked, which of these reasonable restrictions were not part of the original constitution? In the original constitution, security of the state was, decency and morality was, contempt of court was, defamation was. Later, through constitutional amendments, sovereignty and integrity of India, friendly relations with foreign states, public order, incitement to an offence, all these were added through constitutional amendments. For example, public order was added as a reasonable restriction on your freedom of speech and expression by the first Constitutional Amendment Act, 1951. That's it. Let's look at reasonable restriction on 19(1)(b). For example, you have the fundamental right to assemble peacefully without arms. This is not an absolute fundamental right, because in the interest of sovereignty and integrity of India and public order, there can be restrictions on your right of assembly. So listen to me carefully, understand and memorize all these reasonable restrictions. Can be important for your exam. If you have the fundamental right to form union, association and cooperative society, again, this is not an absolute fundamental right, because in the interest of the sovereignty and integrity of India, public order and morality, reasonable restrictions can be imposed on this fundamental right. If you have the fundamental right to move freely throughout the territory of India, to reside and settle anywhere within the territory of India, this is also not an absolute fundamental right, because reasonable restrictions can be imposed in the interest of the general public or for the protection of the interest of any scheduled tribe. For example, your right of movement can be restricted during COVID, which is in the interest of the public. Leprosy patients, their right of residence can be restricted because of reasonable restrictions in the interest of the general public. And you know, there are areas which are dominated by the tribes. Your right to movement in these areas can be restricted. For example, the Jarawas of Andaman. For example, the Shonpins, the Nicobaris of the Nicobar. Clear? Similarly, when you have the fundamental right to carry out on with any trade, any occupation, any business, any profession, again, this is not an absolute fundamental right, because in the interest of the general public, it can be restricted, because you cannot say, if I have the fundamental right to carry on any trade, I might trade in the contraband, I might trade in the psychotropic substances, narcotic drugs, because that would not be in the interest of the general public. Similarly, the state can prescribe technical qualification, professional qualification, which means, yes, you may have the fundamental right to become a doctor, but for that you can't say that I will perform a surgery at this hospital because this is my fundamental right. I can take up any trade, any occupation. But for this particular job, technical qualification, professional qualification can be prescribed. Only you should be an MBBS or an MS, then you can perform the surgery. Or the state may exclude you from such trade. For example, in atomic energy. Can you trade in atomic energy? Make that your business? The state can either exclude you partially or completely from this activity. That's the power of the state. That's a reasonable restriction under Article 19. And Article 20 talks about 3 things. 3 clauses, 20 clause 1, clause 2, clause 3. 20 clause 1, for example, I am teaching polity at an academy. Is it a crime? It's not a crime. Tomorrow, can it become a crime? Yes. But can it become a crime with a retrospective effect? No. In a sense, If I know teaching polity on Unacademy is a crime, I won't indulge in it. I won't start teaching because I know it's a crime. But can I teach polity on Unacademy with this fear that tomorrow it may become a crime and it will apply retrospectively? That means it will apply from that date when I was teaching polity, when it was not a crime. This is similar to what we have in the US Constitution, no ex post facto criminal legislation. Which means the legislature cannot enact a criminal law and give it a retrospective effect. The effect has to be prospective. That means this law can enter into force at a later date, from a future date, not from a previous date. That's 20 clause 1. Similarly, 20 clause 2, no person shall be prosecuted and punished from the same offense more than once. Something similar to US Constitution, no double jeopardy. Which means if you have committed a crime for which you have been serving your time in the jail, once you are released, you cannot be prosecuted by the courts again for the same offense. No person shall be convicted and prosecuted and punished for the same offense more than once. 20 clause 3, this is something which is found in the US Constitution. Right against self-incrimination. Which means no person shall be compelled to become a witness against himself. Which means the prosecution will have to independently prove whether you have committed a crime or not. You cannot be forced to become a witness against yourself. And that is why tests such as narco-analysis, polygraph, brain mapping, lie detector test, these are all considered to be unconstitutional. Also because they violate 20 clause 3 and also because they violate right to privacy, which is a fundamental right. But one thing that you must keep in mind, that DNA fingerprinting is not violation of Article 20 clause 3. But we shall discuss that separately at the time of the mains examination. Here, just keep in mind that Article 20 talks about 3 clauses. 1, legislature cannot enact a criminal law and give it a retrospective effect. 2, no person shall be prosecuted and sentenced for the same offense more than once. And no person shall be compelled to become a witness against himself. And then we have one of the most important rights under the Constitution, under Fundamental Rights chapter, Article 21. The state shall, no person shall be deprived of his life or personal liberty, but it is not an absolute fundamental right, which means your life or liberty can be snatched from you, but only according to the procedure established by law. And this the Supreme Court said in the Maneka Gandhi case, 1978, that it primarily means due process of law. And not just do we follow due process of law, we also follow principles of natural justice. But what is the difference between due process of law, procedure established by law? What do we mean by the principles of natural justice? We will not discuss here because we are discussing only the bare act, what is there in the Constitution. And Article 21 capital A was added by the 86th Constitutional Amendment Act 2002, where there is a fundamental right to primary education, that the state shall provide free and compulsory primary education to all children in the age group of 6 to 14 years. That means for all the children in the age group of 6 to 14 years, you have a fundamental right to free and compulsory education. That's Article 21 capital A, which originally was not part of the Constitution, was added via 86th Constitutional Amendment Act 2002. And Article 22, which is not available to enemy aliens, and it is not available to those who are under preventive detention laws. Constitution says under Article 22, no person who is arrested shall be detained in custody without being informed. Informed of what? Of the grounds on which he or she was arrested. And the interpretation given by the Supreme Court is that you should be informed in a written format. If you have orally informed the person you are arresting, that does not satisfy Article 22. You have to inform the person you are arresting of the grounds that too in written. And every single person has the right to consult or be defended by the legal practitioner of his choice. Which means I have the fundamental right to choose a lawyer of my choice. The state cannot say, no, not Mr. Harish Salve, you go and find someone else. That is not the right guaranteed by the Constitution. And further, Constitution says, it's mentioned in the Constitution, that whoever has been arrested, you have to be produced before the nearest magistrate within 24 hours of your arrest. But this time period of 24 hours has to exclude the time of the journey. You may be brought from Assam to Delhi, and the time that it will take for you to be brought from Assam to Delhi does not have to be included. Which means we will have to exclude that travel time, the journey time, and focus on the remaining time. And within 24 hours of that time, you have to be produced before the nearest magistrate. That's Article 22 of the Constitution. But as I told you, this right does not apply to those who are enemy aliens, and this right does not apply to those who are under preventive detention laws. And even those who are arrested under preventive detention laws, maximum arrest can be for 3 months. Can this arrest be beyond a period of 3 months? For that, an advisory board has to be set up. Sir, is it mentioned in the Constitution? Yes, mentioned under Article 22. Article 23 and 24 talks about another category, right against exploitation. What Article 23 says? Prohibition of traffic in human beings and begar and forced labor. Which means what Article 23 prohibits are some exploitative practices. For example, traffic. For example, begar. For example, other forms of forced labor. What is begar? If you are forced to work without being paid wages, without being suitably paid, that's begar. It's an exploitative practice. Traffic in human beings, not the Bengaluru traffic. Traffic means buying, selling of men, women and children like goods. That is traffic and prohibited under Article 23. Is slavery mentioned in Article 23? Slavery is not explicitly mentioned, but Supreme Court had said in Dubar Gola case that although slavery is not explicitly mentioned under Article 23, but it would be covered under Article 23 because it is exploitative practice. So Article 23 prohibits traffic, begar and other forms of forced labor. But you need to understand, is this an absolute fundamental right? No. Because there will be instances where you may be forced to work and for which no wages will be paid, nothing will be paid. And who can force you to work? The state. The state can impose compulsory service on you. For example, there is a tsunami, there is an earthquake, or there is a war, where the state will impose compulsory service on you that you have to work, for which we are not bound to pay you anything. That's an exception to Article 23. But now listen to me carefully when I say this. When the state imposes such a compulsory service on you, the state shall not discriminate only on the grounds of religion, race, caste, or class. That means the state cannot impose compulsory service on Hindus and not Muslims, on Dalits and not on others, on poor and not rich. If the state has to discriminate, state can discriminate on the grounds of age. The state can impose compulsory service on those who are between 18 to 25. The state can discriminate on the grounds of sex, imposing compulsory service only on men and not women. The state can discriminate on the grounds of, let's say, residence. We will impose this compulsory service on those who are in Odisha, because the problem is in Odisha or in the neighboring states. We will not impose this compulsory service on the Punjabis. That's Article 23. And Article 24, now listen to me carefully. Who is a child? Somebody who is less than the age of 18? Or somebody less than the age of 16? Or somebody less than the age of 14? Or somebody less than the age of 12? For example, what is the age of criminal liability in India? If there is a child who is below the age of 7, no matter what he does, what she does, you are not liable for your actions. But if you are above the age of 7 till the age of 12, you will be liable for your actions, provided you have a mature mind, provided you know what you're doing, you're aware of what you're doing, you're aware of the consequences of your act. And the child above the age of 12 is liable for his actions. So who is a child? Somebody less than the age of 12? Or less than the age of 14? Less than 16? Less than 18? Who is a child? This can be important for your exam. According to the Constitution, under Article 14, when Constitution prohibits child labor, the child is defined as somebody who is below the age of 14 years. No child below the age of 14 shall be employed to work in any factory or mine or be engaged in any hazardous employment. And to give effect to this Article 24, Parliament enacted a law called Child Labour Prohibition and Regulation Act of 1986, which was amended in the year 2016. And for the first time, that law talks about adolescents as well, those who are in the age group of 14 to 18. But we don't have to go there because we are discussing the Bare Act. According to the Bare Act, child labor is prohibited. A child less than the age of 14 is prohibited to work in any factory or a mine or be engaged in any hazardous occupation and employment. That's Article 24. Let's look at a question. Which of the following are envisaged by right against exploitation in the Constitution of India? This question was asked in 2017. Can you tell me what is the right answer? Prohibition of traffic in human beings covered under Article 23, because right against exploitation deals with Article 23 and 24. Prohibition of employment of children in factories and mines. Abolition of untouchability is Article 17, right to equality. Protection of the interest of minorities is under Article 29 and 30. So what is the right answer? 1 and 4. C is the right answer. Let's look at right to freedom of religion, Articles 25 to 28. Listen to me carefully. Article 25. Normally what happens? Constitution first provides a fundamental right, then imposes a reasonable restriction or provides an exception. For Article 25 is an exception. In a sense, first there is a reasonable restriction and then a right has been provided. How? Constitution says subject to public order, morality and health, you will have this fundamental right, which means you can profess, practice and propagate your religion. You have the freedom of conscience. You can choose any religion. You have the fundamental right from religion as well. You can stay atheist, agnostic. But listen to me carefully. Is your right to freedom of conscience and your right to freely profess, practice and propagate your religion only restricted on the grounds of public order, morality and health? Are these only limitations, restrictions on your freedom of religion? No. Constitution says subject to public order, morality and health and subject to other provisions of this part. Which means your freedom of religion can also not violate freedom of equality, right to equality under Article 14. Cannot violate untouchability, clause under Article 17. Cannot violate the right to live with dignity under Article 21. And that is why when there were rules in Sabrimala temple, which says that women in the age group of 14 to 50, they are not allowed to pray inside the sacred sanctorum of the Sabrimala temple, where the presiding deity is Lord Ayappa. Lord Ayappa is a celibate brahmachari or eternal celibate, Neshtika brahmachari. The Supreme Court said no, this would violate. And Justice Chandrachud at that time said, this violates Article 17 because this is some form of untouchability under Article 17. Your freedom of religion is not restricted only on the grounds of public order, morality and health. It is also subject to other provisions, other fundamental rights under Part 4 of the Constitution. Part 3 of the Constitution. And then look at the explanation. It's mentioned in the Constitution. So tomorrow if there is such a statement asked in the exam, you should not look surprised because the explanation is mentioned in the Constitution. And what is that explanation? Wearing and carrying of kirpan is part of the professing of your religion by the Sikh community. So the Sikhs who are wearing and carrying the kirpan, it is considered to be part of their professing their religion. It's mentioned in the Constitution. Similarly, reference to Hindus, because integral to Article 25 is reform. Constitution says that all these Hindu temples should be thrown open to all sections and classes of Hindus. That's mentioned under Article 25. And Constitution provides an explanation that this term Hindus includes Sikh as well, Jains as well, and Buddhists as well. It's mentioned in the explanation to Article 25. And Article 26 further talks about freedom to manage religious affairs. Every religion or every religious denomination, subject to public order, morality and health, you will have the fundamental right to establish and maintain institutions, whether these institutions are for religious purposes or charitable purposes. Which means every religion, whether it is Hinduism, Islam, Christianity, they will have those who subscribe to these religions, they will have the fundamental right to maintain and establish institutions. But not just religious denomination, every religious community and religious denomination, which means within Muslims, Shias and Sunnis, they also have this right separately. Or within Shias, Dawoodi Bohras, they will also have that right. So every religious denomination also has that right, that you can maintain, establish religious institutions of your choice, whether it is for religious instruction, religious purpose or for charitable purpose. Which means you can acquire movable property and immovable property. That is your right under Article 26. And as an aside here, the Keshavananda Bharti, the famous Keshavananda Bharti, the landmark case, the case was filed by the Keshavananda Bharti before the Supreme Court using Article 26 because he claimed my Article 26 has been violated by the Kerala legislature because they enacted a law. But be that as it may, let's look at Article 27. No person shall be compelled to pay any taxes. Something like jizya that was imposed during the Mughal period, which although Akbar tried to remove, but Aurangzeb reinstalled it. Such a religious tax is impermissible under the Constitution of India, which means it is this Article 27 which lays down the secular character identity of India. No person shall be compelled to pay taxes, the proceeds of which will be used for the promotion of any particular religion. That means, can you be forced to pay tax which can be used for the construction of a temple or construction of a mosque? No, that is something which is impermissible under Article 27. And Article 28 becomes important, especially for the upcoming exam. Why? Because there was a judgment of the court related to AMU, Aligarh Muslim University, whether Aligarh Muslim University is a minority educational institution or not. But sir, that would be covered under Article 30. But that has a close relationship with Article 28 as well. Is AMU a minority educational institution? That is not yet decided by the court. What the 7-judge bench of the Supreme Court has decided? It has decided what is the criteria which the court has to follow to determine whether an institution is a minority educational institution or not. What is that criteria? And that criteria which has been laid down by the 7 judges of the Supreme Court will have to be used by the 3-judge bench of the Supreme Court to decide whether AMU is a minority educational institution or not. But be that as it may, what is Article 28? Can religious instruction or religious worship be allowed in educational institutions? Religious instruction, can you be imparted with the knowledge of Islamic theology or Buddhist philosophy or New Testament? Can this religious instruction be imparted in educational institutions? Or can you be forced to perform religious worship? Can you be forced to perform puja or namaz or praying to the Father, Son and the Holy Ghost? Constitution says under Article 28, no religious instruction shall be provided in any educational institution which is wholly maintained out of the state funds, because the state is secular. Which means if there is a government college or a university or a school which is wholly maintained by the funds of the state, there no religious instruction can be provided. But this will not apply to that institution which is established by a trust. For example, if no religious instruction can be imparted in an educational institution which is wholly maintained by the state, this does not apply to that educational institution which is set up by a trust. For example, madrasas, for example, mats, for example, Khalsa schools, for example, convent schools. Because these have been set up by trusts, and these trusts, they want religious instruction to be imparted. Further, what Article 28 says, very important. If you are attending an educational institution which is recognized by the state, for example, recognized by UGC, recognized by Medical Council of India, recognized by the Bar Council of India, recognized by the All India Council for Technical Education, recognized by Indian Council for Agricultural Research. If you are attending such an educational institution which is recognized by the state or which is receiving aid from the state, which is receiving funding from the state, no person who is attending such an educational institution shall be required to participate in any religious instruction or shall be forced to participate in any religious worship unless and until such person has given his consent. Without my consent, you cannot force me to participate in this religious instruction or religious worship. But what if I am a minor? Then my parents will have to give the consent. That's mentioned under Article 28 of the Constitution. And Article 29 and 30 deal with cultural and educational rights. Article 29, it talks about protection of the interests of minorities. But this term minority is not defined in the Constitution. So what Constitution says? And again, this Article 29 and 30 are exclusively available to citizens. That means now we have come across 5 fundamental rights which are exclusively available to citizens. Article 15, 16, 19, 29 and 30. These are the fundamental rights exclusively available to the citizens. Other fundamental rights are available to citizens as well as foreigners, aliens. But Article 22, the protection under Article 22 is not available to those who are enemy aliens, although the protection is available to citizens as well as aliens. Article 29 says every section of citizens residing anywhere within the territory of India, if you have a distinct language, script and culture of your own, and you want to preserve that culture, you want to conserve that culture, you will have that fundamental right. And we can say it is this Article 29 which speaks about unity in diversity. Constitution does not envisage unity in uniformity. Constitution envisages unity in diversity. Because if you have a different, distinct language, script and culture of your own, you want to preserve it, you will have the fundamental right to conserve it. And Supreme Court in one of its judgment has said this right to conserve your language also includes the right to agitate for the conservation of your language, for the protection of your language. Article 29 clause 2, it says no citizen shall be denied admission in any educational institution which is maintained by the state or which is receiving aid from the state only on the grounds of religion, race, caste, language or any of them. Which means if the state has to discriminate, there must exist other grounds. Other grounds can be sex, other grounds can be age, other grounds can be 6, 7, 8, but merely on the grounds of religion, race, language or caste, there can be no discrimination in getting admission to an educational institution, which is either receiving aid from the state or is maintained by the state. And Article 30 specifically talks about all minorities, whether based on religion or language, which means Constitution recognizes minorities of 2 types, religious minorities and linguistic minorities. And what is the right that they have? They have the right to establish, maintain and administer educational institutions of their choice. Which means they can establish a school, a professional college, a technical college, a university, whatever they want. They will have the fundamental right. And Article 30 further says, when the state has to grant funds to educational institutions, it should not discriminate while granting funds on the ground that this is a minority educational institution. That means the state can fund even minority educational institutions as well. And these caste-based reservations, such as reservation for SC, ST, OBC, EWS, this does not apply to minority educational institutions. That is why there are various communities, for example, the Lingayats of Karnataka, who are demanding a minority status, primarily because they want the benefit of Article 30. Which means if we get minority status, then we can establish, maintain and administer educational institutions of our choice, which means then we don't have to follow SC, ST, OBC, EWS reservation. And in fact, we can reserve up to 50% of these seats for our own religious community, for our own communities. That is Article 30 of the Constitution. There used to be Article 31 as well. But this Article 31 was repealed through 44th Constitutional Amendment Act, 1978. And instead we have Article 31 capital A, Article 31 capital B, Article 31 capital C. And these are very important because of various Supreme Court judgments over the past 1.5 years and can be important for your exam. So listen to me carefully. Article 31 capital A, it talks about no matter what is mentioned in Article 13. What is mentioned in Article 13? That state cannot enact any law to delete, modify, abridge a fundamental right. This will not apply if the state wants to acquire an estate. If the state wants to take over the management of any property, if the state wants to merge, amalgamate different entities, which means even if you violate Article 14, Article 19, Article 31, an exception is provided under Article 31 capital A. That means the law can be passed by the Parliament. And through that law, you can take over an estate, you can take over land, you can amalgamate 2 or more corporations, you can take over the management of an estate, even if it violates Article 14, 1931. Now listen to me carefully. Can state legislature make such a law to take over an estate, to take over the property and thereby violate 14, 1931? Yes, state legislature can also pass that law. But that law should have been reserved for the consideration of the president. If that law does not get the consent of the president, then that law cannot violate Article 14, 1931. That law cannot take over the estate, the land, the property of individuals. That's Article 31 capital A. Article 31 capital B talks about 9th schedule, which means any law which is placed in 9th schedule, that law is immune from judicial review. Judiciary cannot question the validity of that law. And in fact, the law placed in 9th schedule gets a retrospective effect, which means no such law which is placed in 9th schedule shall be deemed to be void or ever to have become void. Retrospective effect. That means the law provided under Schedule 9 of the Constitution, and Schedule 9 was not originally part of the Constitution. It was added to the Constitution by the first Constitutional Amendment Act, 1951. And any law which is placed in 9th schedule, you cannot say it is violating fundamental rights. Because what does Article 13 say? The state cannot enact any law to delete, abridge fundamental rights, because that's the limitation on the state, which means that's the limitation on the Parliament. But then if such a law which violates fundamental rights is placed in 9th schedule, it is immune from judicial review. There is no judicial review. Although later the Supreme Court said in Vaman Rao case and then again in IR Kolo case that all such laws which are placed in 9th schedule before 24th April 1973, there can be no judicial review, but the laws placed in the 9th schedule after 24th April 1973, there can be judicial review. And what happened on 24th April 1973? The landmark Keshavananda Bharti judgment, in which the Supreme Court held that there is something called basic structure which is beyond the emendatory powers of the Parliament. And then in 1980, in Minerva Mills case, Supreme Court said judicial review is part of the basic structure of the Constitution. Then Article 31 capital C. Let's look at the question. The 9th schedule was introduced in the Constitution of India during the Prime Ministership of. Let me know what is the right answer. Ninth schedule was added by the first Constitutional Amendment Act 1951, and in 1951 who was the Prime Minister? Pandit Nehru. This question was asked in Prelims 2019. Now Article 31 capital C, listen to me carefully. This was added by 25th Constitutional Amendment Act 1971. And this was primarily to give effect to two directive principles, 39B and 39C. And these two directive principles we will discuss later in DPSPs. 25th Amendment 1971 introduced 31 capital C in the Constitution. And Constitution said if the Parliament wants to enact a law to give effect to implement 39B and 39C, and in the process if Article 14, 19 and 31 is getting violated, the law cannot be declared unconstitutional merely because it violates 14, 19 and 31. Which means it is this 31 capital C which gave primacy to two directive principles over three fundamental rights. Clear? But then this Article 31 capital C was amended again in 1976 during 42nd Constitutional Amendment Act. And this time Parliament said, we don't want to give primacy to only two DPSPs over three fundamental rights. We want to give primacy to all DPSPs over three fundamental rights. And whenever we will pass such a law to give effect to any DPSP, if it violates 14, 19 and 31, merely on this ground, the law should not be declared unconstitutional. And in fact, such a law cannot be questioned in any court of law. That means there is no judicial review. When this amendment was challenged in the court, this amendment was challenged in a famous case known as the Minerva Mills. Supreme Court said, no, this amendment is unconstitutional. Why? Because it disturbs the balance between DPSP and fundamental rights. And this balance between DPSP and fundamental rights is also part of the basic structure of the Constitution. Which means when this amendment was declared unconstitutional, what was the status of 31 capital C before this amendment? Before this amendment, 39B and 39C had primacy over 14, 19, 31. This is the existing situation. But listen to me carefully. If the question is asked in the examination, according to 31C, what is the text of the Constitution? 31C says no law which gives effect to the policy of the state under Part 4 of the Constitution, Directive Principles, shall be deemed to have been void, that it is inconsistent with Article 14 or 19. And such a law cannot be challenged in any court of law. That means 31 capital C gives primacy to all DPSPs over two fundamental rights, 14, 19, because 31 was deleted in 1978. Which means when you are amending the constitution and then this constitutional amendment is declared void, unconstitutional by the court, that doesn't mean automatically constitution gets changed, their wording changes. It remains the same because it does not get deleted, but the interpretation changes. Interpretation is now that we will go back to 39B and 39C having primacy over 14 and 19 because 31 got deleted later. Long story short, Article 31 capital A, capital B, capital C. What is 31 capital A? A law can be passed by the parliament or by the state legislature. If state legislature is passing such a law, this law should get the consideration of the president, should get the approval of the president, should be reserved for the president. Otherwise, the state law will not enter into force. But what is 31 capital A? If the state wants to pass a law to take away land or estate or management of an industry or a factory or amalgamate corporations, this law shall not be declared unconstitutional on the grounds that it violates Article 14, 19, 31. And Article 31 capital B talks about 9th schedule. And any law which is placed in 9th schedule, there is no judicial review. Which later on, because of the interpretation of the court said till 24th April 1973, no judicial review. After that, there is judicial review. And 31C specifically talks about giving primacy to two directive principles over two fundamental rights. 39B, 39C will have primacy over 14 and 19. Full stop. Then we have Article 32, which Dr. Ambedkar said is the fundamental of all fundamental rights. Because if Article 32 is not provided, which means all these fundamental rights would be as if they are just mentioned on a piece of paper and it's a worthless piece of paper. Because you have right to equality, you have right to freedom, you have right to life, you have right to religion, but there is no way in which you can enforce these rights. But the beauty is Article 32 provides a remedy in case your fundamental rights are violated. And an even beauty is that this right itself is a fundamental right. This remedy itself is a fundamental right. And Constitution says that you have the right to move the Supreme Court, because these fundamental rights are enforceable in a court of law. And how will Supreme Court enforce these fundamental rights? By issuing various directives, by issuing various writs. And are these writs mentioned in the Constitution? Yes. Habeas corpus, mandamus, prohibition, certiorari, quo warranto, mentioned in the Constitution. And it is through these writs that your fundamental rights are protected, enforced, safeguarded. And that is why we say Supreme Court is the protector of your fundamental rights. But listen to me carefully. Can some other entity apart from Supreme Court or High Court be empowered to issue these writs? What if such a question is asked in the exam? The right guaranteed by this article shall not be suspended except as otherwise provided by the Constitution. That means this Article 32 can be suspended only during national emergency or some other steps which we will discuss. But even during emergency, which we will discuss tomorrow in emergency provisions, Article 20 and 21 are not suspended, or their enforcement is not suspended. But can some other entity be empowered to issue such writs? Yes. Who can decide that? Parliament. Parliament can also provide some other authority this power to issue these writs. That is important, can be asked in the examination. Okay? Great. Let's look at Article 33. These fundamental rights which are guaranteed by the Constitution, these fundamental rights, some of them are not applicable to some. For example, can members of the armed forces claim that we have the fundamental right and we will form a union? Can they claim freedom of speech and expression? Can the BSF Jawans or CRPF Jawans claim freedom of speech and expression? Article 33 gives power to the Parliament, that Parliament, what you can do, you can modify these rights for certain people. Who are these people? Those who are the members of the armed forces. For them, these fundamental rights can be restricted or extinguished. The members of the forces which are charged with the maintenance of law and order, for example, police, CRPF, persons who are employed in intelligence agencies, for example, Intelligence Bureau, R&AW, Research and Analysis Wing, or those persons which are working in telecommunication systems of these entities. If you're working in telecommunication system of Army or CRPF or in intelligence agencies, your rights can be restricted, which means some of the rights may not be provided to you. And who will restrict these fundamental rights for such entities? That power is with the Parliament, not with the state legislature. And Article 34 talks about something called martial law. The fact of the matter is that this term martial law is not defined in the Constitution. Then what does Article 34 talk about? During martial law, there are people who are tasked with maintenance of law and order. They have to do anything to maintain law and order. And after martial law is revoked, can such people be brought before the court of law saying during martial law they violated our fundamental rights? No. Which means power is with the Parliament. That under Article 34, you can give immunity to these people who are tasked with maintenance of law and order when martial law is in place, so that when a martial law is revoked, then no case should be filed against such people on the grounds that during martial law they violated our fundamental rights. That's Article 34. But what is this martial law? It has not been defined. Now listen to me carefully. Article 35. Parliament has the power and the legislature of the state does not have this power. Which power? To make law with respect to matters related to Clause 3 of Article 16. What is Article 16, Clause 3? I told you that if there can be no discrimination on the grounds of residence, but Parliament can provide residence as a qualification for certain jobs, only at the state level, not at the union level. So to give effect to Article 16, Clause 3, Parliament has that power, not the state legislature. Clause 3 of Article 32. What is Article 32? Constitutional remedy. Writs such as habeas corpus, mandamus, prohibition, certiorari, quo warranto. Can some other entity other authority be also given this power to issue these writs? Yes. Who can give any other authority this power to issue writs? That is something that is the power available with the parliament, not the state legislature. And Article 34, which means to protect those people who are tasked with maintenance of law and order when martial law is in place. Who can provide them protection? Parliament, not the state legislature. Which means on all other matters, who can make a law? State legislature. But on these matters, 16 clause 3, 32 clause 3, 34, only Parliament has the power to make law. But something else. Part 3 of the Constitution talks about certain offences, such as untouchability is abolished and its practice in any form is forbidden. And if you are still practicing untouchability, that shall be punishable by law. But who will pass that law? Who has the power to enact such a law? That power is with the Parliament, not the state legislature. Which means prescribing punishment for those acts which are declared offences under Part 3 of the Constitution. That power to prescribe punishment is given to the Parliament, not the state legislature. That's Article 35, and that brings us to the closure of Fundamental Rights, Part 3 of the Constitution. Now let's look at Part 4 of the Constitution, which deals with directive principles of the state policy. In simple terms, what are those principles which direct the state when the state is making policy, when the state is enacting laws? That's what we call directive principle of the state policy. And this is where we discuss Articles 36 to 51. Fundamental rights from 12 to 35. DPSP, Part 4, 36 to 51. 36 talks about definition of the state, which means these DPSPs are positive obligations on the state. Fundamental rights are limitations on the powers of the state. Fundamental rights are basically negative obligations, where the state is asked, please don't interfere with the liberty of an individual. Please stay away. Don't interfere. Stay away. Negative obligation. But in directive principles, we are asking the state, please interfere. There's a positive obligation on you. Please interfere so that you can enact a uniform civil code. Please interfere so that you can establish village panchayats and empower them with powers so as to enable them to function as units of rural, local self-government. Please interfere so that you can provide for equal pay for equal work. Please interfere so that you can enhance the living standard of the people. Please interfere so that you can provide for maternity relief. Please interfere. Positive obligation. And here we are asking the state to interfere. And who is the state? That definition is provided under Article 36. And the definition is same as that of Article 12. So the definition of the state under Part 3 is same as the definition of the state under Part 4, which means the definition of the state under Article 12 is the same as that of the definition of the state under Article 36. But then Article 37 talks about something beautiful, something important. Article 37 says, and it talks about two important characteristics of DPSPs. These principles, although they direct the state when the state is making policies, which means what are the principles that the state has to keep in mind when the state is making policies, when the state is enacting laws, but these principles shall not be enforceable in a court of law. Fundamental rights are enforceable, but DPSPs are not. But nevertheless, it shall be the duty of the state to implement these DPSPs, because these DPSPs are fundamental in the governance of the country. That doesn't mean that DPSPs are inferior to fundamental rights. Although Mr. B.N. Rao, who was the constitutional advisor to the drafting committee, he had criticized that DPSPs should ideally have been fundamental rights, should have been ideally part of the Part 3 of the Constitution, should ideally have been enforceable in a court of law. But that doesn't mean Part 4 is inferior to Part 3, it just means that the state needs time and resources to implement DPSPs. Because these DPSPs are important, fundamental in the governance of the country. And when I said right at the start that the questions have been asked in the prelims examination from Indian polity in such a manner that you can assume that statements are directly lifted from the bare act and provided to you in the form of questions. And the conclusive evidence of that is the next few questions that will be there on your screen. This question was asked in Prelims 2020 with reference to the provisions contained in Part 4 of the Constitution of India. Which of the following statements is or are correct? They shall be enforceable by courts. They shall not be enforceable by any court, but these principles laid down in this part are to influence the making of laws by the state. D is the right answer, because it is mentioned that these are not enforceable in any court. But what are these principles which direct the state when the state is making policies? Which means these principles are there to influence the making of laws. 2 and 3, D is the right answer. Consider the following statements regarding DPSPs. The principles spell out the socio-economic democracy in the country. The provisions contained in these parts are not enforceable by any court. C, 1 and 2 is the right answer. Because fundamental rights are for the promotion of political democracy. And DPSPs are for the promotion of the socio-economic democracy, which means the principal objective of DPSP is to ensure the creation of a welfare state. According to the Constitution of India, not according to you, according to the Constitution of India, which of the following are fundamental for the governance of the country? And the answer is C. Why? Because look at Article 37. The provisions contained in this part shall not be enforceable by any court, but the principles laid herein are nevertheless fundamental in the governance of the country. And that is what the question is asking. But Article 39, I told you that Article 39 Clause B and Article 39 Clause C, these are very important for you to understand. Because Article 39B and 39C, these are obligations on the state. What are the obligations? That the state shall direct its policy, because these are the principles which direct the state when the state is making laws, enacting policies. The state shall direct its policy to ensure that the ownership and the control of material resources of the community are so distributed so as to subserve the common good. And the operation of economic system and the means of production shall not result in the concentration of wealth to a common detriment. That means whatever policy the state is making should not lead to concentration of wealth in fewer hands. There was a judgment of the court given by Justice V.R. Krishna Iyer, known as the Krishna Iyer Doctrine, which later on was supported by Justice Chinnappa, the Chief Justice of India, wherein they said material resource of a community includes a private property as well, which means a private property is also the material resource of the community and as such can be distributed amongst the people. But a 9-judge bench of the Supreme Court last year in 2024 in Bombay Private Property Owners Association said not all private property is the material resource of a community. So this phrase material resource of a community becomes important for your upcoming exam. 39B talks about ownership of the material resource of the community shall be so distributed so that it subserves the common good. It leads to maximum happiness for the maximum number of the people. And no matter what economic system you use, it should not result in the concentration of wealth to a common detriment in fewer hands. Look at the question asked in Prelims 2021. under the Indian Constitution, concentration of wealth violates what? Directive principles. Because 39 clause C says it should not result in the concentration of wealth. If it results in the concentration of wealth, you're violating DPS. In prelims examination, at least 2 times in the past, question has been asked, which of the following DPSP was added by the 42nd Amendment to the Constitution? So you have to understand and you have to remember and memorize that there will be some DPSPs which were originally part of the Constitution, but some were added later through amendments. 3 directive principles were added by 42nd Constitutional Amendment Act 1976. For example, 39 capital A, equal justice and free legal aid. Participation of the workers in the management of the industries. In fact, this question was asked in the prelims examination. Which of the following DPSP was added by 42nd Amendment? One option was participation of workers in the management of the factories. This is the right answer. Third, protection and improvement of environment, safeguarding forests and wildlife. This was also added by the 42nd Amendment. So these are the 3. There are 2 more which were added not by 42nd Amendment but by some other amendments. For example, promotion of cooperative societies through 97th Amendment, 2011. Provision for early childhood care and education to children below the age of 6 years. This was done by the 86th Constitutional Amendment Act 2002. Why? Because Article 45 previously said education to children in the age group of 6 to 14. It was basically a directive principle. Later, this directive principle became a fundamental right by the same constitutional amendment when Article 21 capital A was added to Part 3 of the Constitution. When for children in the age group of 6 to 14, education becomes a fundamental right and not a directive principle. That is why this directive principle was substituted, renamed, reworked to now talk about early childhood care. That means it shall be the duty of the state to provide early childhood care and education to all children below the age of 6 years. Article 49 talks about protection of monuments and places of objects of national importance. Just like Article 40 talks about panchayats. Article 44 talks about Uniform Civil Code. Article 49 talks about protection of monuments and places and objects of national importance. 50 talks about separation of judiciary from executive, because we are a parliamentary democracy where there cannot be a strict separation of powers between executive and the legislature. So there is separation of powers between executive and judiciary as provided under Article 50. And Article 51 says promotion of international peace and security. And in fact, this was the question asked in the exam. In Prelims 2014, in the Constitution of India, promotion of international peace and security is included in promotion of international peace and security is included in B, directive principles of the state policy. Right? Okay. Then Part 4 capital A of the Constitution. This was added by the 42nd Constitutional Amendment Act 1976. Article 51 capital A was added. Initially there were 10 fundamental duties added, but by 86th Constitutional Amendment Act an 11th fundamental duty was added. That means in total we now have 11 fundamental duties mentioned under Part 4 capital A of the Constitution under Article 51 capital A. And you need to remember and memorize these fundamental duties. And for that, if you have been attending my classes, I give you one acronym to memorize these fundamental duties, which I will now share. For example, you become an IPS officer and over a period of time, you are promoted as the Senior Superintendent of Police, SSP. But you are corrupt. Suddenly there is a knock at your door, and outside we have people from the anti-corruption unit. Gentlemen, you are under arrest, and you will claim innocence, saying, I have not committed any crime. The anti-corruption unit will show you a DVD which has the proof that you have committed a crime, you have taken bribe. What will you do? In panic, you will resort to PR, public relations. You will call Aarambh Goswami and tell him, don't broadcast this news today, saying the nation wants to know why this SSP has been arrested, because nation clearly does not want to know. Maybe you will call your journalist friends and tell them not to publish the story. That's what we call PR. And ultimately, what will happen? You will win. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. These are 11 fundamental duties. Which are these 11 fundamental duties? To abide by the Constitution, respect its ideals and institutions, the national flag and the national anthem. To cherish and follow the noble ideals which inspired our struggle for freedom. To uphold and protect the sovereignty, unity and integrity of the nation. To strive towards excellence in all areas of human endeavor. To safeguard public property and to abjure violence. To protect and improve the natural environment, including forest, wildlife, and to have compassion for living creatures. To defend the country and render national service when called upon to do so. To value and preserve the rich heritage of our composite culture. To defend the country and render national service when called upon to do so, or to develop scientific temper, humanism and spirit of reform and inquiry. PNR, to promote harmony. R, renounce the practices which are derogatory to the dignity of the woman. And W is the last one which was added, which means there is a duty on a guardian or a parent that you have to provide opportunities for education to all the children in the age group of 6 to 14. It is this one which was added by the 86th Constitutional Amendment Act 2002, because this is related to education. So 86th Constitutional Amendment Act added Article 21 capital A, added Article 51 capital A clause K, and rephrased Article 45 of the Constitution. These are 11 fundamental duties provided under Part 4 capital A of the Constitution. Let's look at some of the PYQs. Under the Constitution of India, which one of the following is not a fundamental duty? So if you recall SSP, DVD, ACU, PR, W, you will know that duty to vote in public elections is not a fundamental duty. This question was asked in 2017. Which of the following statements are true for fundamental duties? A legislative process has been provided to enforce these duties. Is it mentioned anywhere in the Constitution that if you violate these fundamental duties, this is the punishment that you will be given? No. That means these fundamental duties are not legal duties, which means you cannot get these duties enforced in a court of law, which means a legislative process has been provided to enforce these duties. They are related to legal duties. Which of the statements are correct? D, neither 1 nor 2. In 2017 itself, in the context of India, which of the following is the correct relationship between rights and duties? Rights are correlative with duties. Let's pause. Rights are personal and hence independent of society and duties. When Fundamental Duties chapter was introduced, amended into the Constitution, Srimati Indira Gandhi was the Prime Minister. She was asked what was the need to amend the Constitution and provide for fundamental duties. She said, and I quote, "People are aware of their rights. I want to make them aware of their duties." So there is a correlation between rights and duties. Rights are something that you can claim from the state. Duties are some things that you have towards the state. You have to abide by the Constitution, respect its ideals, national flag, national anthem. So rights are correlative to with duties. Rights, not duties, are important for the advancement of the personality of the citizen. Duties, not rights, are important for the stability of the state. Rights are personal. So A is the right answer. Rights are correlative with duties. Okay. Now let's look at part 5 of the Constitution. And in part 5 of the Constitution, we will focus on the Union. Sometimes what is part 5 can also be asked. Because when we will discuss PYQs tomorrow as well, I'll tell you that in one part related to municipalities, it was asked. They did not ask specifically about municipalities. They asked that this part 9 capital A deals with what? So you should know it deals with municipalities. So what is part 1? Union and its territory. Part 2, citizenship. Part 3, fundamental rights. Part 4, directive principles. Part 4, capital A, fundamental duties. Part 5, union. Okay? And those of you who have not yet liked the session, do press the like button now and let's continue. Article 52 is the shortest article in the Constitution. It says there shall be a President of India. And the implication is that this word shall makes it mandatory that someone has to occupy the post of the President of India. This post cannot remain vacant even for a brief moment. Somebody has to occupy this post. We cannot imagine and envisage our constitutional functioning without somebody occupying the post of the President of India. And Article 53 says all the executive powers of the Union, of the centre, shall be vested in the President. Article 53 itself says that the supreme command of our defence forces shall be vested in Parliament, in the President. That means who is the supreme commander of defence forces? It's the President of India. But further, listen to me carefully, can be important for your exam. Nothing in this article, because in this article what is mentioned? All executive powers are with the President. That doesn't mean that if there are functions, executive powers conferred on other institutions or other entities, those executive functions will be transferred to the President. Number one. Number two, Parliament has the power that you can confer by passing a law some of these executive functions on authorities other than the President of India. So what are you trying to say? We are discussing Union, part 5. Article 52, the shortest article in the Constitution, it says there shall be a President of India. Article 53, all the executive powers are with the President. Although what is this executive power is not defined in the Constitution. But this executive power is with the President. The command of the defence forces is with the President. But can Parliament prescribe some of these executive powers to any other authority other than the President? Yes, Is it mentioned anywhere? Yes, it is mentioned in the Constitution. Keep that in mind. This can be a verbatim statement asked in your prelims exam. Similarly, Article 54 talks about the election of the president. The president is elected by the members of the electoral college. An electoral college consists of elected members of both houses of the parliament, elected members of the legislative assemblies of states. And the explanation provided is that in this Article 55, state includes National Capital Territory of Delhi and Union Territory of Puducherry. Because these are the union territories which have a legislative assembly. But sir, what about Jammu and Kashmir? Are J&K MLAs also part of the electoral college to elect the President of India? The answer is no. Why? When Parliament amends a federal provision of the Constitution or a federal feature of the Constitution, for that you have to amend the Constitution, and this constitutional amendment bill should be ratified by not less than half of the states. One such federal feature is if you want to change the manner and method of the election of the president. Which means originally Constitution said electoral college will consist of elected members. That means not nominated members. Elected members of both houses of the parliament. Elected members of the legislative assemblies of the states. That's it. But when Puducherry MLAs, Delhi MLAs, because these are union territories, when they were made part of the electoral college to elect the President of India, which means you are changing the manner and method of president's election, which is a federal feature. Including Delhi and Puducherry MLAs was done through a constitutional amendment, and this constitutional amendment was also ratified by not less than half of the states. So if tomorrow J&K MLAs are to be made part of the electoral college, for that constitution should be amended. And this constitutional amendment needs ratification by not less than half of the state legislatures. Because that's exactly the procedure that was followed when Delhi and Puducherry MLAs became part of the electoral college. That's Article 54. Article 55 talks about manner of the election of the president. Manner in the sense that the president shall be elected based on the system of proportional representation system by means of single transferable vote to secret ballot. It also talks about calculation of the value of vote of an MP and MLA. Do you know that formula? What is the value of vote of an MLA? Total population of that state divided by total number of elected MLAs into 1 by 1000. What is the value of vote of an MP? Total value of votes of all the states divided by total elected representatives in the parliament. But when we say total population, that population figure is of 1971 census. This is mentioned where? In Article 55. So Article 55 not only talks about that president is elected by the system of proportional representation system by means of single transferable vote through secret ballot, it also talks about the formula basis which you calculate the value of vote of an MLA and the MP. Value of vote of an MP of Rajya Sabha is equal to the MP of the Lok Sabha. But value of the vote of an MLA varies from state to state because that is based on the population. Which population figure do we take into account to calculate that value? That is the 1971 census. Where is it mentioned? In Article 55 of the Constitution. Article 56 talks about the term of the office of the president. And listen to these points carefully. These are very, very important points and directly can be asked in your examination. The president shall hold office for a term of 5 years, provided that president may, by writing address to the vice president, resign from his office. So if the question is asked, the president resigns by submitting his resignation to, he submits his resignation or she submits her resignation to the vice president. Now the president may also be removed from her office through a process called impeachment. Where is it mentioned? Article 61. All of you would be knowing it, or most of you would be knowing it. But then what is the difference between Article 61 and Article 56? So what are you trying to say? Last year in the prelims examination, there was a question on Article 109 that was related to money bill, which we will discuss tomorrow. The procedure for a money bill. A large number of students were confused. Why? Because they would have always read that it is Article 110 which deals with money bill. But what is the difference between 109 and 110? 109 talks about procedure of money bill. 110 talks about definition of money bill. Similarly, Article 56, if tomorrow the statement is asked in the exam, according to Article 56 of the Constitution, the president is removed through a process of impeachment for violating the Constitution. You should not say that this is incorrect because it is mentioned in Article 56. Then, sir, what is mentioned in Article 61? Article 61 talks about procedure for amendment, procedure for impeachment. Procedure in the sense that this process to impeach the president can be initiated in either Lok Sabha or Rajya Sabha. If it is initiated in Lok Sabha, then 1/4 of the members have to write to the speaker. If it is initiated in the Rajya Sabha, then 1/4 of the members have to write to the chairperson. Then this resolution should be passed by not less than 2/3 of the total membership of the House. So that procedure that we need to follow to impeach the President of India, that procedure is mentioned under Article 61. Then what is mentioned in Article 56? Grounds for the impeachment of the President. And the President may be impeached from her office on the grounds of violation of the Constitution. But then what is the procedure to impeach the President? That's provided under Article 61. The President shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. This is to prevent something called interregnum. There shall be a President of India, which means this office cannot remain vacant even for a brief moment. Somebody has to occupy this post at all times. And if the term of the President is 5 years, but we have not yet conducted the election to appoint or elect the successor, then even beyond 5 years, the same President can continue to remain in office. Why? Because otherwise there would be vacancy. That is not permissible under Article 52. And any resignation that the President addresses to the Vice President, what Vice President has to do with this resignation? Vice President will have to communicate as soon as possible, forthwith, to the Speaker of the Lok Sabha, informing him that there is a vacancy in the office of President. I am going to occupy that post. This article is very important for your exam. Article 56 of the Constitution. Donald Trump, unfortunately or fortunately, cannot contest elections again to the post of the President of the United States of America unless and until he amends the Constitution, which seems difficult because in US you need ratification by 3/4 of the states. Because in US there is a limit. The same person cannot hold the office of the President of the United States for more than 2 terms. That means there is a limit for re-election. But is there any limit on re-election? No. Is it mentioned in the Constitution? Yes. Where? Article 57. A person who holds or has held office as president shall be eligible for re-election to that office any number of times. There is no limit. But what is the qualification? Remember this carefully. Listen to me carefully. According to Constitution, what is the qualification? You shall be the citizen of India. You must have completed 35 years of age. You should be qualified to become the member of the House of People, which means you should be qualified to become the member of the Lok Sabha. And at the same time, you should not be holding any office of profit. Where is it mentioned? It's mentioned in Article 58. But if you are a minister, can you contest election to the post of the president? Or will you being a minister be considered to be office of profit? And as such, you are not qualified to contest election. Explanation is provided in the Constitution itself. That for the purpose of this article, a person shall not be deemed to hold office of profit by the reason only that he is the president. That means the president, can he contest election again? Yes. But can you then say that president, since you are the president, you are not qualified to contest the election for the post of president because you are the president and you are holding office of profit? Because you are the vice president, since you are holding office of profit, which means first you resign as the vice president and then contest election to the post of the president? No. Which means the president, vice president, governor, minister, whether at union or any state, you can contest election to the post of the president of India. And once you are elected, then you can resign. Just because you are holding these positions, that does not mean you are holding office of profit. And as such, disqualified from contesting elections. Where is it mentioned? Article 58 of the Constitution. Article 59. Listen to me carefully. Important fact. The president shall not be a member of either House of Parliament or a House of the Legislature of any state. That means, can you be the member of the Parliament and the president at the same time? Member of the state legislature and president at the same time? No, you can't. Although president is part of the Parliament, but he is not a member of Lok Sabha, member of Rajya Sabha. But what if there is a person who is a member of the Parliament and contest election to the post of the president? Who is a member of the state legislature and contest election to the post of the president and wins the election? Then you shall be deemed to have vacated your seat on the date you enter upon the office as the president. Which means what? Which means I am the member of Parliament or member of the state legislature. Now I have contested election. Now I have won the election. That means before the election I need not resign. But after the election, either I should resign, or the moment I enter office, the moment I have administered oath, it shall be deemed that I have vacated the seat in that house. Where is it mentioned? Article 59 of the Constitution. Normally we have third schedule of the Constitution. And it is this third schedule of the Constitution which talks about the oath or affirmation. Oath is for a believer. I believe, I swear in the name of God. Affirmation is for non-believers. I solemnly affirm that I will faithfully discharge the duties of my office. Normally this oath is mentioned in the third schedule. For example, the oath of a minister, the oath of the Prime Minister. Although the direct oath is not mentioned of the Prime Minister, but the oath of a minister is mentioned. Oath of the CAG, oath of the judge of the Supreme Court and High Court. This is mentioned where? In Schedule 3 of the Constitution. But the oath of the President is mentioned in the article of the Constitution itself under Article 60. And who administers oath or affirmation to the President? Chief Justice of India. In the absence of the Chief Justice of India, the senior most judge of the Supreme Court. Where is it mentioned? Article 60 of the Constitution. And Article 61 talks about the procedure for impeachment. Article 62. Time of holding election to fill vacancy in the office of the President and the term of person elected to fill casual vacancy. The President, your term is for 5 years. When do we conduct election? And this election is conducted by the Election Commission of India. When should the Election Commission of India conduct the election to elect my successor? I am the President of India. My term is for 5 years. When should Election Commission of India conduct election to elect my successor? Before my term is over. That is what is mentioned in the Constitution. An election to fill vacancy caused by the expiration of the term of the office shall be completed before the expiration of the term. That means you don't have to wait for my 5 years to get over and then conduct election to elect my successor. Even before my term is over, you have to conduct the election. This is to prevent interregnum. There shall be a President of India, which means this office cannot remain vacant even for a brief moment. Second, what if there is a vacancy in my office, but it is not because my term is over, but because I am dead, because I resign, or because I have been impeached? That means now there is a vacancy in my office. Not because I have completed my term, but because of other reasons. Then when should Election Commission of India organize elections, hold elections? Within 6 months when this situation has arisen. That means I have resigned today. Election Commission could not have predicted this, that I will resign before completing my 5-year term. Or I am dead. How could they predict? Or if I am impeached? They could not predict it. So when I am impeached or I am dead or I have resigned, within 6 months, Election Commission of India should organize elections. That is mentioned under Article 62 of the Constitution. But now listen to me carefully. For example, Rahul Gandhi got elected to Lok Sabha from Raebareli as well as Wayanad. But since you can't be holding 2 constituencies, you can't be the representative of 2 constituencies, you had to resign from 1 constituency, and he resigned from Wayanad. And now from Wayanad, fresh election had to be conducted. That means by-election had to be conducted. And Priyanka Gandhi Vadra got elected from Wayanad constituency. For how many years? For the full 5 years? Or for the remainder of the term? For the remainder of the term. Which means if the term of a Lok Sabha MP is 5 years, after 2.5 years, I resign, or I am dead, or I am disqualified. That means now we need a by-election to fill this vacancy. And somebody who gets elected will remain in office for the remainder of the term. That means for the remaining 2.5 years. But this is not applicable for President, which means if my term as the President was for 5 years, but within 2 years, I am either dead or I am impeached or I resign. That means that within 6 months, you have to elect another President. Will that President hold office for 3 years or for full 5-year term? That President will hold office for a full term of 5 years. That is mentioned in Article 62 itself. Clear? Are you enjoying the session, or this is becoming too much and I should end the session now? Yes, sir, end the session. Okay. Article 63, there shall be a Vice President of India. That's mentioned in Article 63. Again, one of the shortest articles in the Constitution. But Article 52 is the shortest because it says there shall be a President of India. The mere adding of this term vice makes it slightly longer than Article 52. And Article 64 says, what is the role of the Vice President? The Vice President shall be ex officio Chairman of the Council of States, which means this vice president is not an MP of Rajya Sabha. Despite the fact that you are not an MP of the Rajya Sabha, you still preside over Rajya Sabha. That means your role is similar to that of the Speaker of the Lok Sabha. But you are presiding over Rajya Sabha because by virtue of the office that you are holding, and that office is that of the Vice President of India. Which means for Vice President, first, Constitution says there shall be a Vice President of India, and this Vice President will be the ex officio chairman of the Council of States, which means the Rajya Sabha. Vice President to act as President or to discharge his functions during casual vacancies in the office or during the absence of the President. There shall be a President of India, which means this office cannot remain vacant. Which means whenever there is a vacancy, because of death, because of resignation, because of impeachment, then Vice President will act as the President of India. For how much time? Till the new President is elected. That means Vice President will act as the President of India till the new President is elected, which should be done when? Within 6 months of the vacancy. That means maximum time I can act as the President of India is 6 months. But listen to me carefully. Does the Vice President act as the President of India only if the President has died or has resigned or has been impeached? What if President is in the office? Can still Vice President act as the President of India? Yes. When? If the President is sick, or if the President is absent because of illness or some other cause. For example, 2 times when Dr. Rajendra Prasad was the President, he was alive, but during his term, 2 times Vice President acted as the President of India. One, when Dr. Rajendra Prasad was ill. Second, when he was in Russia on a foreign visit. Which means Constitution says when the President is unable to discharge his functions. And when are you unable to discharge your functions? Maybe because of illness or some other cause, because of which you are absent. The Vice President shall discharge the functions till the time President resumes his duties. And when this Vice President is acting as the President of India, he will draw the salary of the President of India. He will have all the immunities of the President of India. And what is that immunity? No criminal case can be filed against the President while the President is in office. That is Article 65 of the Constitution. And Article 66 talks about the election of the Vice President, which means the Vice President is elected by the Electoral College. And this Electoral College consists of members of both houses of the Parliament. And when we say members of both houses of the Parliament, that means these members include elected as well as nominated. And the Vice President is elected by an electoral college through a system of proportional representation system by means of single transferable vote through secret ballot. This is mentioned where? In Article 66 of the Constitution. But then Article 67, it talks about the term of office of the Vice President. The Vice President shall hold office for a term of 5 years, just like the President. But the Vice President may also resign. That means even before completing 5 years, there may arise a vacancy. How? If the Vice President resigns. And Vice President resigns by submitting his resignation to the President. which means president and the vice president, they resign by submitting their resignation to each other. Or vice president may be removed. How is the vice president removed? If a resolution is passed by Council of States, if a resolution is passed by Rajya Sabha, and that resolution should be passed by effective majority. And what is this effective majority? Majority of all the then members of the House. And then this resolution should be agreed upon by the House of People. That means House of People should agree with this removal by passing a resolution by simple majority. But no such resolution can be moved unless 14-day notice is given. This becomes important because recently the opposition tried to remove the Vice President of India. But this resolution was given to the Deputy Chairperson of the Rajya Sabha. Deputy Chairperson rejected this, saying you did not give 14-day notice. You had to give 14-day notice before you can move such a resolution. But if you notice this clearly, Article 56 says that the president can be impeached from his office on the grounds of violation of the Constitution. But there are no grounds of removal mentioned for the vice president. Which means the vice president can be removed on any ground, corruption, inefficiency, whatever. But the grounds are not mentioned in the Constitution. Notwithstanding the expiration of your term, which means your term is for 5 years, but even after you complete your 5 years, you may still continue unless your successor enters upon the office. Where is it mentioned? Article 67 of the Constitution. Similar to president, if the term of the president is 5 years, when do you conduct the election to the post of the president, to the successor? Before the expiration of the term. Who conducts that election? Election Commission of India. Who conducts election of the vice president? Election Commission of India. And this election to fill the vacancy shall be completed before the expiration of the term. But if the vacancy has arisen because of death of the vice president, because of the removal of the vice president, because of the resignation of the vice president, then the election to fill this vacancy shall be conducted as soon as possible after the occurrence of the vacancy, which means here is no mention of 6 months. Under Article 62, this is very important distinction. An election to fill the vacancy in the office of president because of death, resignation, removal, the election has to be conducted to fill this vacancy as soon as possible and in no case later than 6 months. But such a thing is not there mentioned for the vice president. It says an election to fill the vacancy in the office of the vice president, if the vacancy is because of death, resignation, removal, it shall be held as soon as possible once the vacancy has taken place, arisen. But it does not mention 6 months, not later than 6 months. In any case, not later than 6 months. That's not mentioned in Article 68. And once a new vice president is elected, this vice president will remain in office for the full 5-year term, not for the remainder, full 5-year term. Where is it mentioned? Article 68 of the Constitution. And then Article 69 talks about oath. And again, just like the president, the oath and affirmation of the vice president is mentioned in the text of the Constitution itself. It is not something which is mentioned in the third schedule of the Constitution. Clear? And what is this text? That I will bear true faith and allegiance to the Constitution of India as per the law established, and I will faithfully discharge the duty of the office about which I am about to enter. President takes the oath to preserve, protect and defend the Constitution. President takes the oath to preserve, protect and defend the Constitution. But the Vice President only takes the oath that I will faithfully discharge the duties of the office about which I am about to enter. Article 70. Now listen to me carefully. It talks about Parliament may make such provision as it thinks fit for the discharge of the functions of the President in any contingency, in any emergency, which is not provided in this chapter. Which means Constitution says there shall be President, which means this office cannot remain vacant even for a brief moment. If the President's office has remained vacant because of impeachment, death, resignation, then Vice President shall act as the President of India for a maximum period of 6 months, because within 6 months Election Commission will have to organize election to elect the successor of the President. But what if there is no Vice President either? What will happen? Who will preside over? Who will act as the President of India? Not mentioned in the Constitution. That is the contingency. That means something which is not mentioned in this chapter. Who will regulate that matter? Parliament. And this happened when President Dr. Zakir Hussain passed away suddenly. And then V.V. Giri acted as the President of India. Then V.V. Giri wanted to resign because he wanted to contest election to the post of the President of India. During that time, Article 70 was invoked by the Parliament, and Parliament passed a law called President Discharge of Functions Act. It's according to that law that if there is a vacancy in the office of the President, Vice President will act as the President of India. If there is no Vice President, then the Chief Justice of India will act as the President. If there is no Chief Justice, then any senior most judge of the Supreme Court. And the Supreme Court consists of Chief Justice and 33 other judges. At least one of them would be alive to act as the President of India. But this is something which is not mentioned in the Constitution. Listen to me carefully. Can be asked in the exam. Because this is according to the law which is passed by the Parliament. Because Parliament has the power to make a provision which is not mentioned in this chapter, to deal with the contingency which is not provided by this chapter. And what is that contingency? If there is President, President will act. If there is no President, Vice President will act. What if there is no Vice President? The Constitution was silent on this. And to deal with this contingency, Parliament enacted a law in 1969 called President Discharge of Functions Act, according to which if there is a vacancy in the office of the Vice President as well, then Chief Justice of India will act as the President. In case there is vacancy in the office of Chief Justice as well, then a senior most judge of the Supreme Court. Then Article 71 of the Constitution. If there is a dispute with regards to the election of the President and the Vice President, where can you file that case? You can file that case only in the Supreme Court, and the decision of the Supreme Court shall be final. But can you file a case in the Supreme Court just because that Supreme Court, the President's election is invalid or Vice President's election is invalid? Why? Because there was a vacancy in Electoral College. Electoral College consists of members of both houses of the Parliament, elected members, and members of the state legislative assemblies. But there is no legislative assembly in Rajasthan because there is President's rule, for example. That means there is a vacancy in the Electoral College. And since there is vacancy in the Electoral College, the election of the President is invalid. Or the Vice President of India is elected by the members of both houses of the Parliament. Not all members were there because some were vacant. Some MPs were disqualified or dead or resigned, and we had not filled up those vacancies. The election of the president and the vice president shall not be called into question on the ground of the existence of any vacancy for whatever reason among the members of the electoral college electing him. That cannot be the ground. In Article 72, gives power to the president, and a similar power is available to the governor with some distinction, with some variation, which we will discuss tomorrow. The power to grant pardons, to suspend, to remit, to commute the sentences in certain cases. That is the pardoning power or the clemency power of the President of India. And President exercises this power on the advice of the government, because these clemency powers, these are not the discretionary powers of the President. So today we will wrap it up here. Almost 3 hours of the session, continuous, non-stop, uninterrupted and uninterruptible. And we discuss 72 articles of the Indian Constitution. We'll meet again tomorrow, 7 o'clock in the evening, and discuss the remaining bare act, strictly according to the requirement of this examination. And if you're looking forward to that session tomorrow, do let me know in the comment section. And do not forget to press the like button and subscribe to our channel if you haven't yet. And should you wish to get the PDF of the session, that shall be available in my Telegram channel. The link to join my channel is provided in the video description. I'll see you again tomorrow, 7 o'clock in the evening. Till then, have a great time. All the best. Good night.